that's going to be a situation where insurance carriers can rather readily deny the claim on the basis that there's no provision in ERISA that addresses the forfeiture.
This is 401k Specialist Editor-in-Chief Brian Anderson, and this is the 401k Specialist Podcast. Flavor of the month in retirement plan ERISA lawsuits seems to be 401k forfeiture reallocation cases. There's been a dramatic increase in these types of lawsuits lately, where plaintiffs allege that plan sponsors violate ERISA by using 401k forfeiture funds to benefit the company instead of participants. And these types of suits are now top of mind for law firms keen on targeting larger 401k plans in search of sizable settlements. Here to talk about this trend today and what it means to the retirement plan market, we're happy to have Richard Clarke, Chief Insurance Officer at Colonial Surety Company, a leading direct seller and writer of surety bonds, who can speak to why plan sponsors need to remain vigilant in ensuring they have the proper guardrails in place to mitigate the risk of a costly forfeiture reallocation lawsuit. We're also going to ask him about some of the newer SECURE 2.0 provisions that have come into effect this year, and how plan sponsors can safeguard themselves against fiduciary breaches resulting from the new provisions. Welcome to the 401k Specialist Podcast, Richard.
Thank you very much, Brian. I'm glad to be here.
All right. Well, first off, can you just briefly tell us about your role at Colonial Surety Company? What keeps you busy every day?
Yes, Colonial Surety Company is a small direct writer and online insurance carrier based in New Jersey, rural New Jersey. And I function as the Chief Insurance Officer for Colonial Surety Company.
Now, I'm wondering if you can give us a little bit of background on this newer trend of 401k forfeiture reallocation fiduciary breach litigation. What's the claim, and how common are these types of lawsuits right now? I've seen some statistics showing that more than 30 of these types of class action suits have been filed since late 2023. And in the second half of 2024, the number of cases surged by about 35%. Why is this such a hot spot for ERISA lawsuits at the moment?
Well, I think on the heels of what employers, particularly larger employers, had gotten used to in the form of excessive fee litigation relating to their employee benefit plans, comes this, as you describe it, newer trend in forfeiture litigation. And this has to do with an employer setting a time situation, a time limit for which employees are fully vested in the 401k plan. And the understanding, and most employers spell it out reasonably well in employee handbooks, whether or not employees fully understand it or not. But the understanding is that if an employee leaves the employer prior to that specified vesting, if you will, time frame, usually 5 years, in some cases 3 years, that kind of thing, then the employee forfeits in some cases, almost always, the employer contributions to the 401k plan. What the employee has contributed is the employee's, and almost always the employee gets to leave with that. But in more lucrative plans, and in some cases, as you know, employers match employee contributions by healthy percentages. 5% is considered quite good. I've seen a couple of instances where it's more than that, and it can be lower as well. The employee loses that money, and so I think it's fair to say that plaintiff attorneys, particularly those who have a reputation in dealing with litigation against employers on their employee benefit plans, are seizing on that and raising various types of objections as to why the employee shouldn't be allowed to keep the money. But I think the core issue, and the one that's emerging in the statistics that I've seen, and I think I've probably seen the same statistics you have from a survey based upon your quoting of percentages, is that the employers are accused of taking that money, and rather than putting it back at that forfeited money, rather than putting it back into the overall plan assets, they're funneling it for their own usage. And that can be a significant number when you have an organization with a large number of employees and a significant amount of employee turnover over time.
All right. So now, in a nutshell, as I understand it, if forfeitures are not used in accordance with ERISA rules, plan fiduciaries could be held personally liable for breaches. So what can 401k plan sponsors do to mitigate the risk of being hit with this type of lawsuit?
Well, that's a very interesting question because ERISA, that old federal legislation that is the mother of all employee benefit plan legislation, which was effective January 1st, 1975, all the way back in 95, that legislation doesn't make any mention of the issue involving forfeitures. And that's part of the problem because I come from not just an exposure world, but an insurance world. And if you're an employer, you expect, if you purchase insurance coverage, and the two types that are often misunderstood or confused by employers are the required ERISA fidelity bond and the optional liability insurance that addresses, Brian, your comment about the personal liability of those individuals who make employee benefit plan decisions. So that's a dilemma for employers because if you're a plaintiff attorney and you're alleging violation of ERISA and your core case in the allegation has to do with that you violated ERISA through this forfeiture situation, that's going to be a situation where insurance carriers can rather readily deny the claim on the basis that there's no provision in ERISA that addresses the forfeiture. It doesn't mean that the employer still won't have to defend itself and to pay settlements and judgments that arise from the courts, but it's just an issue that when you look to the big piece of legislation that has been amended so many times since 1975 that addresses exposures relating to employee benefit plans, not just 401ks, but all employee benefit plans, there's just no provision for that in ERISA. So that's a bit of a dilemma. Still, it's up to the employer if the allegation is you've converted this money for your own use, and those persons that are fiduciaries, trustees, administrators of the 401k plan can't effectively refute that allegation, then there's going to be a very interesting situation because they're going to be, as you say, personally liable, as well as the organization having some liability as well.
Right. Well, recently, the law firm Schlichter Bogart filed a 401k asset forfeiture lawsuit against Charter Communications that has retirement plan assets approaching $8 billion. So according to that lawsuit, back in 2019, Charter used $16.3 million in forfeiture assets to reduce its employer matching contributions while charging participants $7.3 million in administrative fees. So this is kind of a big new suit involving Jerome Schlichter, who is very well known for excessive fee and pension risk transfer lawsuits over the years. I was wondering if you had any quick insights on them jumping into this arena.
Well, it's a big deal because of the amount of money involved, $16.3 million against a total asset value of the employee benefit plan. And it's real interesting because apparently effective this past January 1st, less than 3 months ago, Charter amended its plan that now mandates that forfeiture assets be used to reduce the company's required employer matching contributions. So that's kind of, to me, that is not a good sign for Charter because they're accused of something and they're going to defend themselves. But then the facts of the matter are that apparently they have very recently amended their position so that they're allowed to use this. So then that would seem to make it, my observation would be, that would seem to make it easier to prove a case that prior to January 1st, if you can prove that they did use the $16.3 million to offset the employer contributions, that might be a little bit easier case to prove, it would seem to me. I'm just using logic and not legal knowledge there, but that would just seem to be an easier situation to prove on the part of the plaintiff attorneys.
Okay. Now I'd like to switch gears a little bit and talk about some of the new SECURE 2.0 provisions and how their implementation creates some greater responsibilities and an increased potential for missteps and claims of alleged fiduciary breaches. So what are some of the primary pain points and challenges that plan sponsors are encountering when it comes to compliance with these new SECURE 2.0 provisions?
Yeah, just a quick little step backward and then we'll step forward. I like these acronyms, and there's always some meaning behind it. So when we talk about SECURE, I like to go back to when the original SECURE was put in place in December of 2019. And just remind myself, I'm talking to myself as much as anybody else, but the SECURE stands for Setting Every Community Up for Retirement Enhancement Act. And I just find that interesting. Then SECURE 2.0 comes along in effective December 29th, 2022. And there are provisions that were required and optional in 2024, and the same is true for 2025. When you look at 2025 and SECURE in general, and then SECURE 2.0, the whole purpose here is for the federal government to legislate making it easier for employees to build some assets for retirement. There was a statement that I saw from the U.S. Census Bureau that said that 31% of employees in private employment situations had no employer-related funds or assets that were dedicated for retirement benefits. So the federal government is really trying to make it easy through provisions, none of which are really earth-shattering, but just trying to make it easy. So for 2025, and before I get there, let me just quote a survey that this is from UBS, United Bank of Scotland, that you're probably familiar with. But it's interesting to me in this survey that employers, less than half of employers in this survey are familiar with the implications of different provisions that have been, in some cases, prior to 2025, but are effective in 2025. For example, one of them is that more than half of those half that are not familiar are not aware of the tax credits available to small businesses for covering administrative costs, not the amount of funds, but the administrative cost. And so I find that there's a lot of misunderstanding that relates to SECURE 2.0. But I think that the provisions that are interesting for 2025, increase in the minimum distribution age from age 72 to 73, penalty-free withdrawals up to $1,000 for emergency situations, an attempt to reach part-time employees in addition to full-time employees. And then employees age 60 to 63, you're getting kind of close to the traditional retirement age there at age 65. But employees age 60 to 63 are permitted to contribute specified amounts of increase to pad their retirement-related assets. So I think that those are all interesting provisions that are part of the big picture, which is that the federal government is trying to legislate making it a lot easier for employees. And obviously, this is aimed at the private employers, that 31%, slightly less than a third of which have employees who apparently have no financial assets that are designated for retirement. So to me, little interesting details that are effective in 2025 that are part of the real big picture of the federal government really trying hard to make it easier for employees to build some assets for retirement. And then, Brian, as you're aware, there's strong rumors that there's in the works maybe a SECURE 3.0 for the future. I just don't know that, and I've been asked to comment on before about, well, what about that? What would that do? And I just think with the current administration and some of the upheaval that we have, I just don't think there's any way to really even speculate about that. It's just not really possible.
I would agree. I don't think SECURE 3.0 is coming anytime really soon.
Yes.
Now, finally, before we wrap up, I'd like to ask you a little bit about how plan fiduciaries are doing in adhering to the Department of Labor's requirements for robust cybersecurity protocols. In general, are most of the plan sponsors meeting the standard, or is there a lot of work to be done?
Well, again, a good question. And I haven't seen any surveys on that would indicate that, but I suspect that the answer to that would be it's being kind of taken for granted. And a parallel I would draw are increasing requirements from various regulatory bodies, depending upon the business that you're in, that the organization participate in enhanced and increased security relating to the cyber type exposure. I think that to a lot of organizations, that means ask your insurance agent about insurance, but it doesn't mean the same kind of protocols that you would use in trying to set up specific procedures that would relate to actually trying to be secure. I think it's more a matter, I would just respond with kind of a gut feeling based upon people I talk to and what I read, that basically it's a matter of waiting until a regulator taps you on the shoulder and says, well, you really need to be doing this, you need to be doing this, as opposed to a proactive approach to security that tries to benefit the organization. That would be my non-scientific but gut response to the question.
All right. This has been great. Anything else you want to touch on? Anything else keeping you up at night before we wrap up?
I just think that employers, and again, focusing on smaller employers, I think there's a lot of room for them to understand and therefore a lot of opportunity for insurance agents to investigate those two key areas that grew out of ERISA that represent exposures, the mandatory fidelity bonding, and Congress way back in 1974, when the legislation was being drawn up, Congress was very specific, and ERISA was very much a bipartisan piece of federal legislation. But they made it very specific about the amount of insurance that you were required to carry for that mandatory surety bond. They gave you a formula, and that's been amended a couple of times because of economic conditions and that kind of thing. And then the optional one, and I go back to a phrase that you use that I think a lot of employers are just not that familiar with, and that is the personal liability of those persons who make decisions on employee benefit plans. I mean, the ERISA legislation says that you are personally liable. And the ERISA legislation also says following that, now, if you want to, you can buy insurance for that, but you don't have to do it. So the mandatory fidelity bonding, the optional fiduciary liability, and I think as I have matured in my knowledge, I've become much more concerned about that optional personal liability exposure aspect. And I like your choice of words. I think even for organizations that are not that knowledgeable, they're aware that there's something else and they confuse the terminology fiduciary fidelity bond or fidelity fiduciary bond. They conflate the terminology, but I think both of those are important. But if I were an individual knowing what I know and I had discretionary responsibility for my employer's employee benefit plans, 401k or otherwise, I would be very concerned that my organization would purchase for me the required insurance coverage as well as the optional insurance coverage.
Well, this has been great. I've learned a lot. Richard Clarke is Chief Insurance Officer at Colonial Surety Company. Thanks for joining us today and sharing your insights on the 401k Specialist podcast.
Thank you very much, Brian. I've enjoyed it.